Where the So we have the second batch of law clerks from Bhutan. Vicky sharing and Ugain sharing. Welcome to Supreme Court of India.
Welcome.
Welcome. My Lord, may I mention?
I wanted to mention Amrapali that new bench is to be constituted. So the earliest period, because 12th of February, Justice Sanjay Kumar says that he cannot continue in this bench because some of his relation is there. In
We are constituting bench. I am aware of that matter. We'll do that.
May I
involving fish workers demolition.
Just take the mic and why this urgency?
Demolition for the 6th of April. We request for this tomorrow, the 15th of April. Otherwise, the matter will be entered in substance.
Take the mic and then speak.
Lordship, I'd like to mention a matter involving fish workers demolition, which is scheduled for the 6th of April. We request for listing tomorrow.
No, there is no such urgency.
Lordship's demolitions may be conducted on Monday, so if maybe take
With my lord's permission.
defects haven't been passed.
Time and again been telling you that whosoever wants to show any urgency, please give it in writing to the registrar. We will examine immediately and wherever we find, we will do it. Otherwise, second day, in any case, it will be listed.
My Lord, may I mention a matter, my Lords, in the Constitution bench matter, my Lords, we have filed the written submission, but with little delay, my Lords, that could be permitted to be taken. In the Constitution bench matter starting, female genital mutation, we have filed the written submission, my Lord, but with the little delay, if written submission could be taken. 4 days delay, my Lord.
The 9 bench matter.
Yes, my Lord.
All right, that is allowed.
My lord, in the Vanishakti matter, that's
Lord, I'll my lord give a letter, my lord, to the registrar, my lord. There's an urgent mentioning, my lord. I'll give a letter, my lord. I know your lordship. I'll do
in the
that.
Vanishakti matter that's listed today, my lord. The state of the
Whoever has given a letter of urgency, we will examine it and where we find
So
that
only-
there is an urgency,
Only,
we will list the matter tomorrow.
Right.
Otherwise, in any case, with the rule of 2 days after the curing of defects, 6th or 7th, the matter will be listed.
my lord, in the Vanishakti matter that's listed today, my lord, in the Vanishakti matter that's listed today, the state of Tamil Nadu, my lord, had filed a separate petition that's shown listed for tomorrow, my lord. So I have copies for the court. Very well.
my lord, only half a minute for that, my lord, because the nomination, my lord, I've been nominated to my lord, represent the Congress party. The last date is, my lord, 6th of, my lord, this thing. But my name is not there in the electoral list. So the appellate tribunal is not,
Not there.
and the appellate tribunal is also not functioning. I don't know where to go, my lord.
Voter if you are not a voter.
No, the appellate tribunal is not functioning, my lord. So I'm not in a corner.
So just wait for another half an hour.
Great.
Appellate tribunal will become functional.
With my
I
lord's
see.
permission, my lords, we had filed the written submissions in the 9-judge bench. Since the number was generated post 12, they're not taken.
Allowed.
Please, wait.
Delay control in 9 bench, whosoever wants to submit today or by tomorrow, you can submit. That which we received yesterday. DO letter from Chief Justice Calcutta High Court yesterday. And of course, both my brothers have also gone through. There is nothing as such, except that we are quite happy and very optimistic about the facts and figure given therein. So is it correct that out of 60,675 till yesterday evening, more than 47 lakh something, those have been disposed of?
Yes, Minister.
And with regard to remaining, on average basis, 1,75,000 to 2 lakh objections are being dealt with every day. And today morning, the Chief Justice has informed us that by 7th April, all objections will be decided.
Yeah, because we are very grateful for that.
May we give
We-
the status report as we have prepared minutes? Status report
yes,
on the
yes,
part
please.
of the Election Commission of
Now,
India.
only two things, yes, of course, we'll consider that.
Yes. Excuse-
Now, as regard to the tribunals, on 20th March, the letter says, on 20th March 2026, the Election Commission of India has notified constitution of 19 appellate tribunals. Before that, the judges were shortlisted after consulting the party. That includes 4 former chief justices also. As reported, the Election Commission has introduced the appellate tribunal portal for the state of West Bengal in their website, and appeals are being filed online and offline. A team consisting of representatives of the Registrar General of the High Court, Election Commission of India, and the state of West Bengal visited the following 7 places to assess the suitability of accommodating the appellate tribunal. Then 7 buildings are mentioned, including the Judicial Academy. And lastly, serial number 7 building was Dr. Shyama Prasad Mukherjee, National Institute of Water and Sanitation.
We have taken permission for 8 weeks where they can commence, if necessary, shift over to Judicial Academy.
So the parties were unanimous that this institute is the best one having infrastructure, and it is in Kolkata. So you have got the permission.
Permission we have got.
So, and I think my brother has also fair knowledge about it. 21 chambers are there, rooms, which can immediately be converted as courtrooms.
We have informed,
So ready-made infrastructure available there.
we've informed the Honorable High Court also, Millets.
Judicial Academy.
And today, training is being imparted. Tomorrow onwards, they can start.
The Institute of Water
That
at Joka.
Jal Shakti Board or something.
Jal Shakti.
Yes.
And I think other issue which we also flagged in the DO letter is that the parties are also unanimous that the appellate authorities venue should be in Kolkata, this place. Now, one thing you have to do it, the Chief Justice has pointed out the Election Commission of India needs to issue necessary notification orders accepting the suggestions of the Chief Justice regarding the payment of honorarium, traveling allowance, and other incidental expenses.
Millets, I am told we have already done that.
If they have done, very good. You keep,
These are the
give a
letters.
copy. We will place it on record.
Is it only one copy?
Very good.
It's today, today.
The appellate tribunal members?
Is it
Yes, today.
Is it a one-day training?
I was told 1 day training, my lords. They could commence tomorrow.
There are four
So for appellate
It's half a day,
tribunal
actually.
concern, what training? Appellate tribunal will decide of the, this is a quasi-judicial authority.
The training, not in
Kindly
the
app-
sense,
Just kindly let me, just.
familiarization.
If your lordships kindly allow me, my lord, kindly allow me to speak. The training was given to the designated officers earlier, to those who have dealt with. Training was given to the judicial officers. Now, one way, my lord, everyone cannot go. Now, the adjudication officer, the appellate tribunal is a quasi-judicial body. If a quasi-judicial body has to take a decision on independently,
Obviously, they will.
And
be
then
independent.
what the-
Former Chief Justice and judges.
no, I am submitting, my lord, kindly, just
Please tell us what is the point.
my lord, why the training? The quasi-judicial authority will.
This is only how to handle the computer, what are the documents to be seen, it's not.
Hand holding.
Why don't you
all
go for training to them?
My lord,
Why will put you also there on for training if you want to go?
no, I do not want to go.
And don't raise
My lord,
frivolous objections.
training, not the merit is concerned. Every time the training is given, the merit is concerned.
It's only orientation, my lords, familiarization.
My lord is not saying merit, he's saying only admit.
Don't worry.
It's not training that they, how to, you will decide the case, it's only how to handle. So today,
I have
suppose
no difficulty, not on merit. my
That's
lord.
what my
That-
lord is
wants me
saying.
to operate a new laptop, I may not be able to, you
No,
may
no,
not
I-
be able
No,
to.
no, no, my lordship is right.
Yeah, this is right.
They are former chief justices and including
Yes.
Justice
Yes.
Shivaganam, I think.
Yes, yes.
Manjula Chalu, Justice
Justice
Sunyama.
from, coming from
No,
Karnataka.
no, there's no doubt.
Justice Shivaganam coming from Madras, former chief justices.
No, no, correct.
They have vast experience
That's
in
right, that's right.
deciding matters. So, Mr. Bhattacharya, you need not be bothered about election commission officers influencing or in any way interfering with their decisions.
All that we want is if there are some administrative glitches, we should be allowed to approach the chief justice, nothing more than that.
Absolutely, why not? Why not?
Just observe that.
Sir,
Doors are always open.
That's right. Just observe that, my lord.
Mr.
Till everything reaches it.
Just observe that, that's all, my lord. We're nothing more than that. We
In groups or and like a delegation.
no, your lordships have on the other day
No,
observed
no, no,
that,
then we will authorize Honorable Chief Justice to not to entertain them.
no,
You can't convert.
no, political
my-
party.
no.
No, not political party.
They have gone, my.
No, no, If the
information-
party has any, my lord, so far our understanding, kindly, my lord, so far our understanding is concerned, the observation was there, your lordship, if anyone wants to tell, communicate something in an administrative side, say something. That is the reason we have said about the, later we have sent it first.
Mr. Kalyan Bandyopadhyay, you can go, Advocate General can go on behalf of the state. If there is some other concern.
Possibly it was my wrong understanding. My lord, I am taking it. It was my wrong understanding. Your lordship said
You being
any
there,
party.
you being there, where is the necessity of the political workers to go?
We agree, madam.
Not the political workers, my lord.
They don't.
No, Mr.
Let us not-
Bhattacharya, this problem is, to the best of our information, representations by political unions or associations are being made not only to the Honorable Chief Justice of the Calcutta High Court,
Correct.
but also to the district judges in the various districts. Now,
No, that I do not know.
Yes.
That we do not know.
well,
That we do
please
not know.
find out.
That
Please
we-
advise
This
them.
is the situation.
That we do not
So
know.
we do not want
Appreciate that. I appreciate that.
to be disturbed by these sort of
Yes, yes.
representations.
That's right.
Whatever, let us
No,
make it.
Your lordship may observe that, in fact.
May I-
No issue on that.
Form of
Dr.
grievance.
Menka will also play double role. There she might have different role, but here she will.
No, I am not playing. I am not. My lord, one role I am playing. Kindly, my lord, your lordship is, do not mind. We are also busy for the election.
Naturally.
We are also,
Your
this is not our important job now.
Your
First,
democratic
just-
exercise will be definitely a part of the electoral process. But the thing is that these judges, they have been really called upon to perform an exceptional duty which is not within the common run of their judicial.
correct.
Very nice, my lord. Since your lordships have,
Situation.
since your lordships have,
They are subjected to representations from various political hues and insinuations being made, well, you have been siding with A or you have been siding with B. It becomes very difficult.
Very nice.
for
No, my
the-
lord, your lordship is absolutely right, my lord. There's no doubt about it. We'll make sure
Mr. Sibal,
that the representation has no political color.
Mr. Sibal, you are there, Mr. Bandyopadhyay and Dr. Goswami are there. Please, any person having a grievance about a
That's right.
decision of a judicial officer, the appellate tribunal is there.
Fair enough.
It's manned by judges who were former chief justices of the
That's
Calcutta High Court. And we have no reason to believe with regard either to their competence, impartiality or capacity. Please advise anyone who is aggrieved, either in the inclusion, unfair inclusion or unjustified inclusion, or unfair exclusion, to approach the tribunal and let the quasi-judicial exercise be undertaken in that objective manner. One thing we need to clarify, because in the last occasion, there was, and the Chief Justice has also in its report flagged the issue of reasons. I was not aware that the software prepared by your client, Mr. Naidu, also has a field where remarks or reasons are given. These remarks or reasons, therefore, is available in the software itself. So if it is possible, whenever a person approaches for an appeal, he may be supplied with the reason,
Yes.
or arrangements be made that whenever an appeal is filed, the appellate tribunal will provide
Will
the
be
reason
given.
to the party concerned,
Absolutely.
permission
We will.
to end the appeal.
That's all we want.
Absolutely.
Address issues which have been raised.
We'll just pass on the whole record. We'll place the whole record before the appellate authority.
Yes, and also the appellate authority will have the right to share it with the aggrieved person and also anyone who's participating.
And the appellate tribunal will also should have the reasons.
Yes, that's good.
And wherever
We
there
do
is a-
abide by that one.
Wherever there is a dispute with regard to genuineness or authenticity or validity of a document, let the tribunals verify it from the official records. They must ascertain the genuineness of such documents and take finally whatever.
So be it.
Yes.
Only one thing, Milord, kindly do not.
Try to mention.
Yes,
Milord,
Mr.
we have never said against.
Mr. Bandyopadhyay.
Kindly unmute Mr. Bhattacharya, my lord.
Yes, yes.
He
Mr. Bhattacharya, you want to
try to make
some?
submission. my lord.
Yes, yes.
I'm-
Mr.
I have not been unmuted.
Yes, yes, you
Yes.
unmuted
There was
and
a
you are
humble,
very
humble
correct.
appeal. The humble appeal is below that the tribunal authority will consider below the documents and records which should be supplied by the applicant. That clarification is not called for. Otherwise, the appellate tribunal will go by below the documents which are not there.
Mr.
That will
Bhattacharya,
be
we are
never-ending
making it
process.
clear because on the last occasion, we made some comments without being
Yes.
aware of the architecture of the software. The architecture of the software provides for a field where remarks or reasons are given by the officers concerned while deciding whether the logical discrepancy was justified and therefore deletion warranted, or it was not justified and therefore inclusion is directed. In such cases, whenever an appeal is filed by an aggrieved person, be it the representative of ECI who feels that the inclusion is unjustified, or be it the person who has been excluded, the reason shall be supplied to the person concerned.
Right.
And the person concerned will have, subject to what the tribunal deems fit and proper, the manner in which he is going to rebut the reasons.
That is there.
Be it on the basis of the documents which are already there
Candidate.
with regard to its authenticity or any other unimpeachable
Yes.
document.
Yes,
Just-
yes. So that should be part of the order.
That's
If we are
fine.
time
That will
constrained,
satisfy us.
if they are
That will
given
satisfy
another
us.
round to have fresh documents placed,
Mr. Naidu,
yes, please.
we are looking at two different, very independent exercises. One is what is the list on the basis of which the election is going to be undertaken.
To be held.
Another is a vital constitutional right to vote.
Yes.
Now, even if a person is excluded today and is unable to vote in this particular election, but that exclusion appears to be unjustified to a tribunal headed by a former Chief Justice, we see no reason why the decision can be altered and he be included. And the likewise, a person incorrectly included and votes for this election, and your representative makes a report to the tribunal, we see no reason why the entire cleansing exercise taken by you should not be taken to its logical.
Indeed, Millets, we are only worried about the time frame. There should be a cutoff date for that inclusion or exclusion.
Cut-off date is.
And
last.
Millets, they have given ample opportunities to file the documents.
Time frame, we cannot decide. It would be the appellate tribunal who.
In terms of that, Millet, the last date for nominations, it can't be beyond that.
We are not saying that.
Yes.
The appellate tribunal decision, if they are within the last day, may be included. But those which spill over beyond
Yes.
the last day or the days that we are making a cutoff
Exactly.
may not be possible to be included in the supplementary list. However,
The right needs to be.
their right cannot be washed away forever.
Yes. That's the fundamental thing.
It becomes an extremely oppressive situation.
I've only flagged the point, Millets, with regard to documents. Then it again, a sort of rigmarole, everything opens up. If they file fresh set of documents.
How can new documents be allowed? Because otherwise there will be an unending process.
So the documents within the specified list must be considered.
If they've been there, they could be considered.
Manoj, may I just come in for, just very briefly?
Another point not is
A
that,
very important issue I wish to flag, Milord. Just very important, Milord.
let me finish, I believe.
Just 1 minute, Milord. Milord, kindly see your lordships by various orders. Observe that all claims and objections should be filed by 14th or 16th February of 2026. And thereafter, the final voter list will be published. Now, final voter list has been published on 28th, and thereafter supplementary voter lists are being published. Now, Milord, the Election Commission has issued a notification. The notification is saying that if one wish to file Form 6, that time is extended. And Milord, under the scheme even, the final up to before voter list, final voter list, on the basis of a draft voter list, anyone can raise objection. Your lordships also made clear. Form 6 cannot be, Milord, done at this stage when the adjudication proceeding is going on. And bundle forms of harm, I am not blaming any political parties.
Today these things are completely premature and hypothetical. Let us see that how the balance of the pending work is completed by 7th, and ultimately what scenario emerges. It's not that neither we are closing today nor.
Yes.
We'll see, let us see then.
Fair enough.
Required, we will intervene to the extent possible.
Kindly see the notification has been made.
Mother's name is not in the list. She is 80, Milord. Some priority may be given in the tribunal.
Milord,
Yes.
The way you are
Standing behind, Milord, about
please, the way you are making out a case before us, please go and make out a case before the tribunal.
Milord,
Yes, but with some preference to the proposed candidates. For
Milord, kindly
consideration.
see
That
the
will do.
notification. Milord, 27 March 2026, this notification has been made by the Election Commission. 27 March 2026, this notification has been made by the Election Commission.
That form 6 can be filed.
Time has been extended.
It's an ongoing process, Millet. When it comes to Form 6, they talked about exclusion, now they're talking about inclusion.
60 and ongoing process.
Millet, Form 6 can be given by any fresh voter. Suppose I complete 18 years today.
Under the 23, under
Yes,
section
ma'am.
23(1), when you publish the final list, the persons who are at the cutoff date will be included. Beyond that, there cannot be any inclusion.
The cutoff date is the last date of nomination.
Is in respect of the draft list which is already published.
May I submit, Millet?
Draft list published with logical discrepancy under adjudication is the only thing.
That's one part with regard to disputed ones. When somebody acquires the voters' right, say for example, Millet, I complete 18 years today. I complete 18 years, I can apply tomorrow.
Extend it till the last date of.
That's what the law is, Millet. Kindly have a look at section 23 minutes. Until the last date of nominations, the inclusion could happen.
Thousands of forms are being filed.
It's an ongoing process. They're undisputed ones.
Bundles of forms, thousands are being filed.
Vis-a-vis the disputed ones.
Can you see the Rule 13? Rule 13 speaks about form for
One,
claims.
Mr. Kalyan, this issue is not before us.
Okay.
I
I understand, Milord. I appreciate.
issue not before.
Milord, I appreciate.
Please raise this issue there before the authorities.
Yes, your lordship will give us liberty to do this.
let them adjudicate. Before the
We have done it. My lord, we have done it. We have done it. 20 itself, we have done it 28th.
May I read minutes?
Lord, I can't show your lordships a video. Your lordships will be surprised to see. The video will show that blood bundle in the CICO's office. In the CO's office.
That's why we have set up 21 tribunals. Now we show these videos.
No, it's on Form 6, Maharaj. He's talking about.
My lords, until now, their grievance is exclusion. Now they have come up with a plea for the inclusion. Kindly have a look at section 23(3) minutes. That's been explicit. If somebody has a right, we can't thwart.
No, but
But if somebody can't have, it has to be stopped. It's as simple as that in my humble submission.
nobody will be able to scrutinize these forms.
Same manner, somebody will have a right to objection also.
That's correct.
Indeed,
That's
my
the
lords,
problem.
anybody can.
That's the
Most
problem.
competent appellate forum has been created. They can,
Chief Justice has indicated that whenever this sort of a situation is occurring, you put your objection under Rule 7, Form 7.
My lord, kindly.
Form 7 is
My lord, what is happening, my lord? Kindly see, my lord. Your lordships have, in these matters, really we are grateful that your lordships have, even bypassing the statutory provisions in a peculiar circumstances, your lordships have laid down certain mechanisms. Right? Considering everything. Now, considering the everything, the adjudication proceeding has also gone appellate tribunal. Now, all of a sudden, kindly, just I am saying, my lord, and I require, I will come up. All of a sudden, 30,000 Form 6 are being deposited by one individual.
Mr. Kalyan, this is absolutely not unusual. It happens in every state. The exercise under 6 is altogether different, but it cannot be done in a hidden manner. Something that if you have a right to object to it, and once you file an objection, it is obligatory.
But we will not know, Maharaj. They'll have to display the list.
Yeah,
The
if that
problem is we will not know.
Procedural part, you know very well.
very, my lord, if that, my lord, kindly, just one clarification, my lord, just nothing I am saying. If any Form 6 is being decided by them, it is concerning the booth is concerned, not the CO office. All Form 6 which have been deposited by them, be notified in the booth itself.
So that we can file an
Yes,
objection.
So that we can file the objection.
Rule 26, sub rule 3.
Whatever you are arguing today is completely verbal. There is not a word before us. We have not read it, we have not seen it, we have not.
All right, my lord, all right, all right.
Millets, once forms,
Please appreciate.
I have deeply obliged.
When we open the.
My lord, your lordship is considered, my lord, maybe we are very,
So,
I understand that, my lord, but your lordship is
You can go even to the extent you might be having a genuine anxiety. But then there is
can raise forms.
but definitely you are not remediless.
not.
Definitely you are not
My
remediless.
lord, we are really, my lord, very
No, we'll.
under tension, no doubt.
On
no
the
doubt
last
about it.
occasion, will
But your
this court
lordship
observe
Form
that
6
the
is
take
given.
care of that.
Once Form 6 is given, under Rule 26(3), it has to be published in a conspicuous place. Objections could be invited, and in Form 7, then adjudication takes place. They can always, anybody has any grievance that can be
But
ventilated.
what is the qualifying
Nobody-
date under
nobody
the
says that
statute, Malad? There has to be a qualifying date
given
with
an-
the statute.
23, whatever 23 deal with that.
No, no. The
23
qualifying
minutes.
date is how the chapter starts. It defines what the qualifier, it'll be 1st of April or 1st of July.
So I think
Now they have arbitrarily changed the date.
That's the problem.
Opening the floodgates against the statute by claiming some back route of the rule. Anyway, it's not before you, but just so that your lordships know, this is what is happening.
Millet, the statute speaks volumes. May I read that one, Millet?
First July was the qualifying date. Now it's whatever date.
No amendment, transposition, or deletion of any entry shall be made under section 22, and no direction for the inclusion of name in the electoral roll of a constituency shall be given under this section after the last date for making nominations for an election in that constituency or in the parliamentary constituency within which that constituency is comprised and before the completion of that election.
This has nothing to do with
This is
rules.
what they have to do with regard to Form 6.
Nothing to do
And
with
Millet,
rules.
then Rule 26, sub-rule 3 comes into picture. It has to be published in a conspicuous place. Anybody has any grievance or objection that can be filed in Form 7. Adjudication takes place. This is completely different from the adjudication undertaken by the judicial officers.
says there are two differences.
My lords.
One is an amendment of the electoral roll.
Correct.
Another is the electoral roll which goes for polls.
Yes.
The electoral roll which goes for polls is as per the qualifying date.
Yes, that's
Because which is announced by the ECI.
Section
It
14.
was announced by the ECI at a particular date, and that is why we had to pass the order that supplementary list shall be
Yes.
cleared
Exactly,
from the
exactly.
date. That does not take away
Married,
a individual's right to include himself under Form 6, but that will not, his inclusion will not give him the right to vote in.
Exactly.
May I
That's
submit,
exactly.
may I submit, Millets? Kindly see Rule 26, Sub-Rule 1A. Kindly see that, Millets. Every such application as is referred to in Sub-Rule 1 with reference to qualifying dates, that is to say the first day of January and first day of April, the first day of July and the first day of October of the year shall be presented to the registering officer in such manner as the Election Commission may direct.
Which rule is a post qualifying date. So anybody who, everyone who has the right to be included. And if it is included before last date of nomination, I will be given.
No. How will
23.
be included in the electoral list?
Sir, it is a dynamic process.
Does not dwell on it and make a final
Because
opinion on
data
this.
is there, but nothing is before us.
If there is,
Because
if there is an objection, raise the objection.
We'll do that. We'll do that.
And we will do it.
We'll do.
But I have a humble appeal that kindly, kindly will not direct plus some preference
Well, we
to
have brought it
the
to your lordship's notice. It's only fair. Your lordship will note it.
Order.
Mr. Diwan, yes, one. That's enough.
Yeah, Manoj, there's just one point I wanted to make.
Lord, I have a,
You already
my lord, I have a submission, my lord, in 1.4. Would your lordships hear me? If your lordships are hearing Mr. Diwan after that.
Mr. Giri, we will hear you also. Let Mr. Diwan from
Very
this side also say.
Very well.
Yeah, but there's just one point I wanted to make, which I'm grateful to the Election Commission for having furnished its latest status report. What we were planning to hand in terms of a note, I think is overtaken by the communication received from the Chief Justice, because that has even more recent statistics. But the point which we wish to make is that on the basis of the information which we have, the degree of inclusion from those approximately 40, your lordships had a slightly larger figure of adjudicated cases now, inclusion rate was about 55% at 19 lakhs. And the exclusion rate, the people excluded pursuant to this adjudication exercise, was in the range of 45%. That's a very, very high exclusion rate. The reason I'm pointing this out is because your lordships can now envisage what is likely the burden before the tribunals which have been established and which are going to start functioning now. So this is there's a very, very high rate exclusion rate, keeping in mind that these are all mapped individuals who have been excluded on the basis of this exercise. One of your lordships know.
Mr. Diwan, on this issue, we will not make any comment for the simple reason. They will assert that all 100% were liable to be excluded. This side will say all 100% were liable to be included. Now this again becomes a contentious and an adjudicatory issue.
Yeah. So Manoj, the second point was that I'm very I'm very grateful to the observation made that the short reasons will be communicated, because otherwise the person is going blind. And I think what your lordships have noticed, that if it is mapped or if it is available on their data, then that should be shared so that a person really knows when he approaches the tribunal.
That we could visualize well in advance, and that's why with these appellate tribunals, that institution.
Very grateful. No, very grateful. And frankly, these 19 lakhs or so who have been included and have been re-enfranchised or enfranchised because of your lordship's directions is a great
because
boon.
of your lordship's orders.
Yes,
The
that's
2 million
a
voters
real
came back.
that's a real step forward.
On one hand,
I have one,
Because
they were
I have
excluded
one
stance
submission to
with
make.
regard to the discrepancies. Judicial officers holding about 45%
That's why on lighter
discrepancies
side we
are
are pointing
correct.
out, Mr. Naidu, that's why on lighter side we are pointing out. Your assertion will be all 100% should be excluded. They will rightly assert all.
Millets, imagine Millets.
One request.
May I have one humble prayer?
One request
Let
is
the
this.
proposed
Kindly,
was decided.
one request.
Things could have
Kindly dispel the idea that we have blamed any judges, those who are in the adjudication. We have not done it, my lord. Kindly just.
Mr. Kalyan,
I have just request to your lords.
we have verbally pointed out. You have appreciated that part. Matter ends there.
That's right.
Matter ends there.
Okay.
Why unnecessary?
Manoj, my final request is, would your lordship,
All right.
That's only
but
because when senior Seasoned advocates are there. We can only communicate something through you people.
Yes, yes, yes.
We can't directly tell anyone.
No,
We can tell you only.
all right.
May I make a very
That Mr. Kalyani is
that
not
humble prayer before your lordship?
leader of the bar also.
Yes, yes.
Yes, yes. Of course, my first love is the profession and I am the officers of the court. That I always say
Whereas
everywhere.
my final point is, would your lordships consider placing the matter on the 6th? Would your lordship consider placing the matter on the 6th? And the reason I mention this is by then we will have considerable experience of how the tribunal is able to deal with the load, because that might just give us some space and time for appropriate direction. So that's my final request. I'm grateful.
Mr. Diwan, you are right. We are also tentatively thinking either because the Honorable Chief Justice has informed us today in the morning. We should
Correct.
And he informs us because he thinks it's duty to update us about all the administrative exercise. So
Yes.
he has informed us that by 7th they will complete this probe. So what we are thinking that on 7th we keep this matter at 4 p.m.
4 p.m., that's fine.
One humble request, will not let the proposed nominees of political parties, will not their application be heard, will not little preference. Otherwise, will not they will not be able to contest. Therefore, the political parties have proposed some nomination. Their will not claim be considered, will not with some preference, so that they can have sufficient time to contest. This
Any person who is deleted and has been proposed as a candidate by a recognized political party can make a representation, and his or her case will be appropriately and promptly dealt with.
deeply
The administrative
That's the humble
glitches vis-a-vis the appellate tribunal process, the Advocate General may be allowed to make a representation.
That's all right, that's
Chief
no,
Justice.
that's no.
Specifically the Advocate General, nobody else.
We are not saying anything. Please let us trust the tribunal because they are mostly very seasoned judges.
My lords, not about the decision makers, the administrative glitches vis-a-vis the process.
That
Because it's a new process, my lords. That's
Dr.
not.
Goswami approached the tribunal member. The tribunal member has sufficient experience to deal with an administrative glitch, and if so, the tribunal member will definitely consult the Chief Justice
Chief
concerned.
If your lordship.
Any issue is
Record this
approached the tribunal.
observation.
Milord,
That's all.
in a
That's
lighter
all.
note, I am requesting Madam Goswami to stay at Calcutta and request all these things to the Honorable Justice in administrative side. My burden will be some
Yes,
lighter.
Mr. Giri, you were saying something.
Lord, in 1.4, that's filed by the Sanatani Sangsad. There was an application that was filed, my lord. There is a diary number, but it has not been numbered, my lord. We have to bring to your lordship's notice something which we will believe is serious.
Is it, has it been filed?
Yes. In the morning it has been filed. I think your lordships may take it up.
You can only list on the next date now. Unless, no, you want to point out, sir.
We just wanted to point out something, my lord, so that if necessary, Dr. Guruswamy or somebody may probably would like to get instructions on that, and the election commission also. But if your lordships kindly come to page 9, paragraph 20, or even before that at paragraph
Maybe have a
14
copy,
on,
Mr. Giri.
yes, I have
Sorry,
handing over a copy to Menaka.
maybe have a.
It has been served on the state council. It has been served. It has been
What do you want to point out from paragraph?
starting from page 7.
We don't have a copy. ma'am.
Paragraph 6, page 6, paragraph 13. Hand over copy. Hand over copies.
Only respond if we know what we're responding to.
No, we'll. It has been served, but I'll hand over copies. It's not listed also. As per the data received by the Inquiry Committee of the National Human Rights Commission from DGP, West Bengal during the period from 24/21 to 26/21, a total of 1934
Now,
complaints.
ultimately, para 17 probably you want to highlight.
Yes. Therefore, only 2.88% of the accused were arrested and most of them are now free on bail. Several teams of the Inquiry Committee visited 311 spots for inquiries and ironically found that in 188 instances, FIRs have not been registered by the police at all. Even in 123 cases where FIRs have been registered. No, my lord, please come to paragraph 20.
Then please add CBI as a party in this.
We'll do that.
Because CBI
Yes.
was entrusted, to the best of my knowledge, by
Yes.
a bench presided over by the then Chief Justice.
Yes.
Transfer the investigations in these post-poll violence
Yes.
cases.
Yes.
So the CBI to
We'll
answer
do-
as to why
we'll do
it
that.
was not made.
My lord, could your lordships kindly give me a minute? My lord, please come to paragraph 20, which is of
At
topical
20, we have seen it is not, the person was not even present who has averred this petition.
Sorry, my lord.
The person who has made this averment says statedly. See the pleading.
Yes.
Statedly, and it is not true to the knowledge of the
My lord,
defendant.
that's a link to the video.
So that's what we are saying.
It's a link to the video, but the video, the authenticity of the video, my lord, could be
Nobody
denied
knows.
or could be
He
affirmed.
was not present.
My lord, I don't know, my lord. One has to look at the video,
You bring it to the notice of the authority.
which we will do. No, my lord, the reliefs that we have prayed for. No, my lord, this is, why this is of importance, my lord, is that because the state is
And the
leading.
CBI as a party with regard to the post-poll violence, what steps they took with post-poll violence.
Sorry.
And CBI as a party first.
No, my lord, we'll definitely do that. Please have a look at, my
Because
lord.
paragraph 15 to 17 are with regard to post-poll violence
That's,
poor arrests being
my
made.
lord, it's part of the narrative leading, my lord, to the reliefs that we have prayed for now with this. Because we don't want a repetition of what happened.
I have a suggestion. Can this application be listed on some day?
Well, Mr.
Let it be
Secretary,
served on us.
We'll list-
Because before impleading
Just-
people, except we
let
don't
me
even know who
just
this party
complete
is.
It's not,
Let me
Who
just-
is this applicant?
it's not been served.
I have served.
Matter,
I have
matter
actually
vis-a-vis the.
No, it's not listed. It's not numbered. There's nothing.
Out-
Just
Servers.
out of the
Whatever my brother has been able to recollect, because
Yes.
this in 2021, when this violence
Yes.
or this kind of
Yes.
these
Yes.
unfortunate incidents of murder, rape, and assault
Yes.
took place,
Yes.
then probably full bench of the High Court had referred the matter to CBI,
Yes, my lord.
and that matter has not landed here in Supreme Court.
Yes, my lord.
So why don't you move an application in those proceedings before the Honorable Chief Justice or before whatever, whosoever the bench is dealing with those things?
My lord, the whole matter is there before your lordships now. And your lordships, what we have prayed for is to set up a monitoring committee, my lord, probably headed by a former judge of this honorable court. And this is the first relief that we have prayed for. And steps to avoid, my lord, a repetition of whatever had taken place in
What is
2020.
the point of bringing that up today?
No, my lord, please consider this.
What
And then if
consider?
your lordships, after hearing my learned friends, or whoever is, my lord, interested in this, and then your lordships may
The
consider
learned
whether.
Chief Justice in
The-
Calcutta is aware of this. If there are any issues, obviously it will be dealt with.
No, my lord, see.
know whether-
We don't even know what these allegations are.
The first prayer is direct to high-level monitoring
Asking any
committee.
order.
Unnumbered, unlisted application on
No,
behalf
this
of a
is-
third party.
This doesn't get them anywhere.
Subject to curing of the defects, the, say on the oral mention, an application in repetition numbers, a paper book of the unnumbered IA in repetition number 1216 of 2025 has been handed over in court. Say subject to curing of the defects, we register directly to list the application on the date fixed, The copies may be circulated to the party.
Very
That's fine.
But if you them to file in the Congress.
great.
My lords,
Deeply obliged.
my lords, petitioner in person in item 1.5. I am grateful this honorable court has
Sir,
placed
already
this
we have
order.
spent 1 hour in this matter now. Please spare us.
My lords, I did not get any chance. You just,
I think what, all the issues have been broadly.
no, only 20 seconds. My lords, only 20 seconds.
May I
I'm
add one
grateful
thing, my lord,
this
for
honorable
CI?
court has placed this matter before a three-judge bench. My limited submission is that this raises a pure constitutional issue requiring independent consideration. My lords, the impugned enumeration form is not prescribed under the rules and therefore lacks authority of law to compel disclosure of personal data. This raises an Article 21 issue. This issue is not state specific and may kindly be recorded independently. I have a short note, my lords.
We will consider the point which you are raising is a very important constitutional issue and the constitutional liberty, private right to privacy, right to protection of data. We will examine in due course. ये elections से निपटने एक बार फिर करते हैं.
But this election also is very important, my lords, because this is a complete violation of constitution. I want small short notes.
West Bengal का election सबके लिए headache हुआ हुआ है इसको.
But this is not state specific, my lords.
This
is
the things are moving in the right direction in a very. You must have seen it now. Most of the issues have been resolved either through judicial intervention or amicably and with the mutual understanding of both sides. You are also helping us. Let us first see that the democratic process is peacefully over, and then the other issue which you are raising, we will consider in due course of time. So that we will not close your issue.
May I submit one thing? For election commission. 6th is the last date for nominations as per the schedule. And we need to come up with the final list by 6th evening or midnight, whatever. Because beyond that, no nominations can be accepted. Assuming that 7th, somebody could be cleared in terms of this adjudication, he can't contest, nor can he do anything with regard to that one. So good, my lords, for phase 1 millets, 6th being the cutoff date, let it be listed 7th morning. We'll request the Honorable the Chief Justice to have the whole thing completed by 6th midnight or whatever the time.
7th.
Because we have to come up with the list by that date.
7th we have constitutional bench. 9.
That's why 4 o'clock.
Either we can list on 6th in the evening.
6th evening millets.
Or 6th at 4 p.m.
So be it.
7th.
6th evening. To take stock and to have the next course of action.
We can list even on 7th morning also. That will slightly delay our sitting of the 9th bench.
But complete picture could be before your lordships.
Then it will
7th at 4.
Complete picture could be before your lordships by 7th morning.
Yes, otherwise election can't be held.
And the entire machinery to identify those 152 constituencies.
Yes, ma'am.
which
That we have been.
closing on
Yes.
6th.
6th.
So that all the logical discrepancies in those constituencies may be
Get finalized
heard.
by the date.
Because the other can.
They can wait,
wait
because
for a
we have
couple
got
of
up to 9th.
3 more days.
So be it. That's what we would like to bring to
Please
your
help
lordships'
the
notice.
Chief, because
We do. We do.
neither the judicial officers, not the Chief Justice, without the assistance of the Election Commission machinery, won't be able to identify the parts and the constituencies which have to take.
The process is on, millets. We'll represent to the Honorable Chief Justice there and see that that gets concluded by that date.
gets concluded by 6th.
6th night.
And remainder can go up to 7th or 8th.
Yes, 7th, 8th.
8th.
you are raising, that is answered by the statute.
Indeed, it's been answered by 23-3. Grateful, deeply obliged.
On 10th March 2020.
7th.
He's passing an order in reference to
Grateful, millets. Deeply obliged.
Petitions were issued through a self-speaking order. After taking notice of the disposal of objections by more than 500 judicial officers from the state of West Bengal, along with 200 officers from the states of Odisha and Jharkhand, to whom an extraordinary exercise of adjudicating the objections in the ongoing SIR in the state of West Bengal were entrusted. It was also resolved through that order, Honorable Chief Justice of the High Court at Calcutta was requested to identify some former Chief Justices / High Court cases for the purpose of constitution of appellate tribunals, so that The orders adjudicating objections passed by judicial officers would be appealed by the aggrieved party before such tribunals. In addition, directions with respect to payment of honorarium, traveling allowances, and traveling, boarding or lodging, etc. for the judicial officers were also issued. As per, after the order dated 10th March 2026, two communications have been received. We have received two communications from Honorable Chief Justice of the High Court at Calcutta. While Chief Justice के लेकर नहीं पहले वाला है. While DO letter dated 21st March 2026 from Honorable Chief Justice updated about the progress, updated the scope disposal of objections by the judicial officers. Besides, the proposal to publish the first supplementary roll on 20th March 2026. The Chief Justice also flagged certain issues in the said communication which have been addressed in due course of time. That's further. There is another communication dated 31st March 2026, which we have received yesterday from Honorable Chief Justice of the High Court. Informing that as on 31st March 2026, till 4:04 p.m., 46,60,135 number of objections have been decided in the entire state against the total penancy of 60,06,675. We are informed that by now, the total disposal has closed 47 lakhs. 47 lakh 30,000. 47 lakh 30,000. The DO letter further points out that on 20th March 2026, the Election Commission of India has notified constitution of 1919 appellate tribunals in the state. These appellate tribunals are headed by former Chief Justices, senior judges of the High Court. A team of representatives of the High Court from Election Commission of India and State of West Bengal, thereafter inspected, have visited various buildings in order to find out a suitable application for the appellate tribunals to function. Eventually, Dr. Shyama Prasad Mukherjee, National Institute of Water and Sanitation, which is an institute run by the Department of Drinking Water and Sanitation, Ministry of JAL-Shakti, Government of India, has been was shortlisted. As the said building was found ready to move accommodation, was found ready to move accommodation consisting of 21 chambers. We are informed by Sri Naidu Learning Council for the Election Commission of India that necessary permission from the Ministry of JAL-Shakti has been obtained, and thus
For 8 weeks we obtained, for 8 weeks to begin with.
suspend for a period of, initially for a period of 8 weeks, so that the terminals become functional immediately. He further informed that the orientation stroke training to the members stroke presiding judges of the appellate tribunals will be undertaken today during the course of day, so that they are well conversed with the handling of the appeals which have been filed online stroke offline. So that they can conveniently handle the software where dealing with the appeals which have been filed online stroke offline. It goes without saying that the Election Commission of India will either seek further extension from the Ministry of Jal Shakti and or another alternative accommodation shall be identified in consultation with all the parties, in consultation with the parties. We have clarified that the appellate tribunals shall function at Kolkata. Next paragraph. As regard to the issue relating to non-availability of regions को comma में कर देना, regions, as pointed out by Lord Chief Justice in the above mentioned communication. Commercial Naidu launched in a council for the Election Commission of India informs that the appellate tribunals will have access to the record, which was placed by the parties.
Yes,
For the adjudicatory authority, namely the judicial officers. That it will be ensured that the members of the appellate tribunal have access to the said record for the purpose of deciding appeals that may be filed, one eye, by the persons whose names have been excluded from the voter list, two eye, or by the authorities of the Election Commission of India who might be aggrieved by inclusion of certain
inclusion
of the names in the revised inclusion of names by the adjudicatory authorities. Next program. It goes without saying that the appellate tribunals will be the appellate tribunal, or you say in order to clarify, so in order to remove any sorts of doubts, we request the appellate tribunals to have full access to the records which were placed before the records of the judicial reports along with the regions assigned by the judicial officers while adjudicating the objections and decide the appeals that may be filed before them after apprising the parties with such reasons. After apprising the parties with such reasons. The appellate tribunals shall be at liberty to evolve their own procedure in accordance with principles of natural justice, and are requested to adjudicate the appeals that may be filed by the parties after giving them adequate opportunity of being heard. So, however, we request the appellate tribunals not to entertain fresh new documents which were never the subject matter of adjudication before police officers.
That will, if anybody wants to rely upon document, scheduled document, that should be considered.
Right. Not to confirm first documents unless without verification, without verifying their genuineness and authentication.
Yes.
Fair enough, fair enough.
Fair enough.
That's good.
Document is necessary for adjudication of
Fair enough, that's fine.
parties. Of the parties. Next paragraph. The only other issue flagged by the Chief Justice of the High Court is regarding non-payment of honorarium. Honorarium along with travel, boarding and other incidental expenses. So in this regard, Sri Naidu and Senior Counsel for the Election Commission of India has placed on record the communication dated 25th March 2026 addressed to the Chief Electoral Officer West Bengal, directing him to release the necessary payments to the appellate tribunal, to the members of the appellate tribunal, to the staff, etc., and to the staff, etc. So, in order to expedite the issue, we direct the Election Commission of India Chief Electoral Officer West Bengal to release the necessary, to make the necessary payment to the officers and members of the appellate tribunal or other allied staff, if any, in accordance with the recommendations made by Honorable Chief Justice of the High Court.
My lords may consider.
The
only
precedents
one
will have
thing
for
is
consideration of the
that
proposed
new
nominees that will be
documents
recorded.
issue may open a Pandora's box. Documents have been filed, they've been scrutinized. If there is any defect, that could be pointed out.
To leave it to the discretion of the appellate tribunal.
Appellate tribunal.
That was in fact restricting the discretion of the appellate tribunal. If, let us say, an unimpeachable. Yes. Go under Article 227.
That could have been filed minutes when they had been given an opportunity.
This is surely not adversarial.
That's not an issue.
Why should CCI be concerned, Malad?
Yes, the whole process gets derailed.
Including voters.
No. ECI should not be bothered with that.
We only wanted the genuine voters to be there.
Yes.
No, of course.
Yeah.
Not, we are also want to see that not
ample opportunity was given to
voters
file
are
your
not
document.
excluded.
You don't find
High
the
Court Judge,
documents.
Chief Secretary, all were excluded.
No. When ample time was given to file documents, you don't file. I know you
The
cry
name of a
foul.
retired judge has been deleted.
Accepted documents which should be allowed to be placed.
Yes.
Investment in excluding people from voting.
Very unfortunate.
Genuine voters who have voted.
Yes, that's why 45% is genuine voters.
We'll see to that.
No, why the elections?
When it's administration officers. Appellate tribunal.
They were issued after the last.
The tribunal will know what to do.
All the other very Chief Justices, senior judges.
Election Commission have done a very bad justice how to function.
What has been mechanically rejected will not be reopened then.
On that. We will leave it to the tribunal. to decide.
Yes.
Whatever they
Yes.
That is, only precedents of consideration of the proposed nominees may be recorded, otherwise it will not be done. If it is done at the last moment, it's difficult for them to contest.
That the tribunal will take it into consideration that such document was not submitted earlier and there should be a justification as to why it is being submitted.
The Chief Justices of High Court. These people cannot. It's no direction.
But when it tells that the new document is to be verified, that
By whom?
by issue of
It is.
But in the Indian National Congress nominated a candidate, the Mohtab Sheikh of Farakka constituency.
Go and how can we grant? And it would be done, election commission will take care of it. as
Within the
quickly as
stipulated.
possible.
Only some precedents to this propose nominees. That will expedite the procedure.
Leave to the tribunal, they will do everything.
But Acharya, how many proposed nominee of a recognized political party is in such a situation?
Maybe not a very big number, not a very big number.
We had
Milord.
14, all are
Therefore,
clear, all clear.
Let it be considered with precedence so that they can be on the fray.
Will assist the Chief Justice and his team to deal with all the logical discrepancies in the constituencies going to poll.
Within the, Milord, we had 14, the 14s have been cleared.
No, maybe Indian National Congress has one.
Yes,
It will-
yes, my lord.
They many have, not very.
Please do.
Milord, about not more than 10, not more than 10.
The Chief Justice of the High Court has informed that the pending objections will most likely be adjudicated by 7th April 2026. So keeping the aforesaid date in mind, we oppose this matter on 6th April at 4 p.m.
Deeply obliged.
Yes.
Grateful, extremely
Grateful, grateful.
grateful.
My lords, only one sentence. My issue may kindly be recorded.
Your issue is definitely there, sir. You are there. We are also alive.
Seven years completed under UAPA in Ranchi, and now it's in Delhi. It's time 7 years in custody. Constitute.
While the learned ASG is appearing online, he may be unmuted for item 2.
10 years nearly is spent in custody. 2 orders of the Honorable High Court of Orissa. First, that the trial should end by December 23, and then that it should end by December 24. Have not been complied with. 25 witnesses out of 64 remain. 39 witnesses have taken 9 years.
Are you, madam, we hope that you are aware of the order which eventually we have succeeded in.
No, please, actually, this is what I want to say, if I can hand this over. Between December 2015 and January 2016, on the same allegations and on the same material, prosecutions in 3 different jurisdictions were launched: Delhi, Orissa, and Jharkhand. In Jharkhand, he was acquitted. In Delhi, he was convicted and sentenced to 7.5 years, which he has undergone. On the basis of the same material, there is a continuing prosecution in Orissa. If I can just hand this over.
No, what is on 23rd March of this very person we are dismissed?
No, that is the SLP against the Delhi High Court's conviction and sentence which he has already undergone. But on the same material.
No, we will not. We'll make sure that trial is concluded now in terms.
If I can then my lords, let my rejoinder come on record, because I've already filed a rejoinder. It was not been.
Counsel for the petition state that rejoinder has been filed. We register directly to tag the same with the paper book. And now in terms of our order of constituting the courts which will hear on day-to-day basis, you tell us that within 3 months, why you will not conclude the trial? Post this matter on sources.
This is an ongoing case, so.
You filed the registry. You have said so. You taken on it.
Yes, we filed it because of the holidays. It's not come on record.
Take it.
So your lordship may give a short date.
Yes. We'll try to do this.
Item 3.
My lords, in item 3, day before yesterday, we moved an adjournment letter in the evening. Since yesterday was evening, it's not come on record.
No, who else is there in the family?
My lords, only the wife.
Where are you staying now?
But my lords, right now I'm staying in Madhya Pradesh in a rented apartment. I've been complying with my lord's order.
You can be permitted to visit.
Let me see instructions. My lords may have it next week.
My lords, they can also, if
Let me
my
verify.
lords, they want, they can also verify the status
In
from
fact,
the
there is
INSOR.
one of the matters where medical bail was cancelled only because
The application seeks modification of the order dated 28th January 2026, whereby the applicant petitioner was released on bail, subject to the condition that he will not enter the state of Chhattisgarh. The instant application has been put on the ground that the applicant's child, born on 17th February 2023, is in critical condition and has been diagnosed with ASD and ADHD. The child is getting treatment at AIMS Raipur in Chhattisgarh. It is stated at the bar that there is no other member in the family except the applicant's wife who can help the child for effective medical treatment. So on this ground, the concession, relaxation in the condition imposed by this court while releasing the petition of bail for my suit, then state council seeks and granted Monday.
Well,
It's time to certain the facts if so required. Meanwhile, the petitioner may be permitted to visit Raipur and consult the doctors on Monday, that is 6th. Or you can, today is Wednesday only, on Friday. Tell him on Friday, to visit his house and also consult the doctors in AIMS at Raipur.
my lords, in Raipur also, we are on the rented accommodation that the wife has taken. So I will be permitted to go there in Raipur.
So what we can do, it's not that you are
No, my lords.
you have been deputy director in mining.
Very well, my lords.
And the allegations are that you mined enough.
I understand, my lords. Highly pleased.
We have given note with it.
My lords, good news is this is not a West Bengal matter. My lords, the Foreigners Tribunal matter, two brothers, your lordships had issued notice. In the case of one, this should have been heard together. We're just requesting a tagging, my lords. My lords, we're just handing over your lordship's order of notice, my lords. I'm very grateful, my lords. You've handed over? I'm grateful, my lords. I think there was some delay, my lords, in this.
Yeah, we shall issue notice for condemnation.
Yes, my lords. Condemnation of delay. Grateful, my lords. Very grateful.
Yes, my lord. Item 5, my lord, this is related to northeastern persons who are staying this site, my lord. Yes, my lord, that issue has been recommended to Attorney General, my lord. For the administrative side, Bej Barua committee has already given entire report, my lord. My issue is, my lord, that when even the investigation is conducted and charge sheet has been filed, the stipulated time frame is not being followed, my lord.
You may ask for the time-bound trial.
Yes, my lord. Yes, my lord.
That we can issue, but don't you think that?
No, only on this issue, my lord. Time-bound trial. Charge sheet has been filed, investigation conducted, 3 years, 4 years pending, my lord. Students go back in between, my lord. They are not here.
Say, in addition to what has been observed stroke directed by this court, wide order dated 18th February 2026, passed in writ petition criminal number 02/2026, in bracket Anup Prakash Awasthi was human and others, comma, it is stated by Shri Pradeep Railan, senior counsel for the petitioner, that the specific relief sought in the instant petition pertains to time-bound conclusion of the trial arising out of FIR number so-and-so, pending before
matter, in Delhi court, so Rohini court, my lord, is there. One FIR is at Rohini court, my lord.
just give the exact, tell your
Exact, I will give, my lord. I will give exact number.
pending for the so-and-so court in New Delhi. So that trial pertains to an unfortunate incident of violence that led to killing of Kania in Delhi in 2014. Having regard to the fact that the occurrence took place in more than 12 years, almost 12 years back, and after investigation, charge sheet has already been filed. So it seems to us that such like matters require prioritization and out of turn adjudication. Consequently, we dispose of this litigation without expressing any opinion on merits or on the allegations. We will request to Honorable Chief Justice of the Delhi High Court to consider such like issues on administrative side and take a holistic policy decision which may ensure a predictive timeline for adjudication of such like sensitive trials on out of turn basis. It goes without saying that the Honorable Chief Justice of the High Court or the Honorable Administrative Judge or the committee of the or the Administrative Committee of the High Court may, if deemed appropriate, issue administrative instructions to the presiding officer in the instant case for expeditious disposal of the trial.
May it please, Manoj. This is a petition which, the contempt petition, looking at order of 16th September 2011, which is page 15. Now, I must say in fairness that your lordships have in Atmalinga Reddy said that when there is a bar in the constitution and in the River Disputes Act, individuals shouldn't actually come to the court with this. But in that, it was an Article 32 petition by somebody dealing with the inter-river water dispute. Two distinctions is one, this is not regarding the water dispute itself, it's regarding the contempt of this court.
This is another species of the water dispute.
No, it's happened before, my lords. I just want to, in fairness, say that your lordships have said that 32 petitions anyway are not maintainable. Mine is only limited.
Contempt. There is no contempt.
There is a decision that they have taken, which is at page 1348.
The Almaty Dam
Yes.
is a part of the order dated 30 or the award dated 30/12 to the interim direction of the tribunal
Yes.
dated 30/12/2010,
Yes.
which was not stayed.
No.
What was stayed?
No, it was effectively stayed because what happens is the minute your lordship says report will not be published, that means it's a stay under the section.
Please come, Mr. Gopal.
Page 16.
Order.
Page
In
16,
our
last
opinion,
line.
there is no justification to stay decision dated 30/12/2010.
That's correct. That's correct.
So 30/12/2010 actually is the order on the basis of which the dam height is being increased.
Correct.
Thereafter, what happened was, on that interim order, there were references by the various riparian states.
Can I draw your lordship's attention, last line of that order, last line.
Correct.
That last line says, we direct that till further orders, the decision which may be taken by the tribunal on the reference petitions shall not be published in the official gazette.
You're absolutely right. That is the 2013 decision.
Correct.
It is not the 2010 to 2010 decision.
Then your lordships are effectively saying that there is a license to go up to 524. That's not the understanding of the states at all. Because 13 comes after this order as a final order, and because it can't be published.
When 13 comes,
yes,
the writ petition was filed,
yes,
and an injunction was on the publication. But it is not staying the 30/12/2010 order.
May I just show your lordships the section from the act, because section 6 has that impact. Just give it to me first. Yes. Section 6 says the central government shall publish the decision of the tribunal in the gazette, and the decision shall be final and binding on the parties to the dispute and shall be given effect by them. 2 says the decision of the tribunal after its publication in the official gazette shall have the same force as an order or decree of the Supreme Court. Now, without a section 6, there is no question of implementing or giving effect to the decision.
Look at this in this way.
Yes.
So there is no injunction.
Yes.
In terms of the order passed by us.
Yes.
In not raising the dam's height. Just consider this. The way you argue, the answer comes from there.
I think I will just withdraw, my lords. I don't want to invite your lordships to give me an order more damaging than the one that I think exists.
Correct. Not a case of. You're coming circuitously through and in the contempt.
No,
you have to.
Because we believe that increase from, my lords, our understanding for 16 years, all of us, all states, is that 519 to 524 is not permitted at the moment. Now,
we are not saying anything.
Yes.
We are looking at it from the narrow compass of contempt.
Very well, very well. In which case, I will not press this, my lords. Just allow me to withdraw it.
Can you stop us straight from going into
when you intervene, I'm grateful.
Please, your lordship. Sir, custody matter, my lords. I'm here with a small prayer, my lords. The expeditious disposal of the special appeal, which is pending.
I think we have to direct the register now not to entertain the
My lords, my lords, may just see page 86 for a moment, my lords. The matter was last taken up on 18th of July, my lords. On 20th, an FIR was filed against the matter, my lords.
Please, my lord, I am appearing item number 8. I have filed an adjournment application and circulated it.
Yes, adjournment letter. There is no letter circulated.
The ARS circulated the letter, my lords.
No, we have not received any letter. You might have circulated in your office.
My lords, I seek a week adjournment. The arguing council is facing some difficulty today. Therefore, I seek a 1 week's adjournment.
No, why should we grant adjournment? We have read the brief. This is not the way to argue in court number 1. You force us to read the brief and then you say you had circulated letter. There is no letter circulated.
My lords, then I will clarify it with the AOR, if my lord may pass over it.
Why pass over? You are there, you argue it, please.
My lords, the arguing, I have not gone through the brief. The arguing council is facing some difficulty in this matter.
What is the difficulty? We can't understand. You decide while sitting at home, there is a difficulty in the senior counsel and therefore court must accommodate you. adjournment is sought without, he claimed that a letter was circulated, a letter for adjournment was circulated, which is not on the record. And the case is called coma. It is again submitted that some senior counsel is to argue, who is not presently available. Post this matter on front.
Please, my lords.
What is the those matters, please? Sixth, so simply adjourn it to sixth, no?
6th April, your lordship may post, my lord.
We are adjourning on sixth so that all matters can be taken together.
Very well.
Like my lords.
I'm requesting for a passover, my lords. I'm being led. My lords, I'm requesting for a passover, my lords. I'm led by Mr. Balbir Singh, senior advocate.
Who is to argue?
Plus Mr. Balbir Singh, senior advocate. He's on his legs in for 2 minutes.
The respondent, Commission for Equality Management. The Commission for Equality Management, respondent number, the main respondent over here, R2, R1.
Are you for CAQM?
Yes, I'm for CAQM. Sorry, I was saying the whole, I was giving the whole name instead of saying CAQM.
You are more familiar with CAQM.
Yes, I'm appearing for CAQM. I'm sorry.
CAQM looks to be a very impressive name, as if you will do something about pollution. We don't know whether you will do or not.
Lordship, I think CAQM has really been working very hard. It's just that, at least in the pollution matter, there are too many other circumstances which kind of have a huge role to play.
Can we take up some on further date? Postpone. There are senior arguing counsel is not available. Post this matter for hearing on something.
Is the Lordship giving a date?
Yes.
Lordships. Grateful, my lords. Gratefully, Lordships, obliged.
My lords, interim relief restraining the respondents from creating third party is granted in 2014. And my lord, since that the petition are pending at the stage of admission. The petitioners are the bona fide purchasers. If your lordships may kindly see page 1.
That is a plea will be examined by the High Court.
All my concern is, my lords, the matter is now, I have filed an application seeking.
Probably.
My lords, the next date is on 8th. So at least if your lordships would direct to consider the application.
Has to direct the High Court.
My lords, my concern since last 1 year.
The High Court is already seized of the matter for final adjudication. And case is now listed on 8th April 2026. We see no reason to undertake this special petition. The petitioner shall be at liberty to raise all contention before the High Court at the time of final hearing.
My lords, may I mention, I had already mentioned the matter for many times and on one date, my lords, it was specific.
Once you will show this order, probably High Court will go.
My lords, I'm only requesting for your lordships, may I kindly observe that to expedite the at least
No,
hearing of
nothing
this
wrong.
petition.
How many
Because
times
since
is that?
last 12 years, my lords, the petitions are pending.
You please go there with this order. We have no reason to doubt.
But I'm requesting just to observe with the, to expedite the
I
hearing.
think 12.
Oblige, Your Honor.
Also, kindly have the photograph, page 36. The entire land is released. My lords, the surrounding area, my lords, which I have shown, entire area is stands released, my lords. My lords, may kindly also have the reply of the state that they have filed. May kindly have the reply that state has, my lords, I know, my lords, there are two things, my lords, I wish to make submission on, my lords. My lords, the entire surrounding area is released, my lords. It is abutting the Abadi, my lords. My lords will see page 36, my lords. That's why, my lords, I've asked them to give a photograph of the surrounding area, my lords. Entire village, my lords, the land was released by the under sections 5A, my lords.
Where is the question of this fraudulent provision of 101A?
But the policy of the state
I'm
government.
surprised why it has not been struck down so far.
My lords, the issue of discrimination has not been considered. I am on issue of discrimination, my lords, not on 101A, my lords. Issue of discrimination has to be considered by someone. My lords, what the Honorable High Court says is, my lords, in this 491 acres or section 4 notification, my lords, award passed 230. After award, 75 more released. Only 150 acres is actually acquired, my lords. Now, my lords, in the reply, they say, my lords, that the land which was required for Metro Depot has already been taken. I have not even filed for that. Only the land on which my houses are constructed, which is abutting the Abadi, my lords, for that, my lords, this case has been filed, my lords. My lords, we consider the photographs and the plight of these people, my lords. This is their only house in which they are staying. My lords, the issue of discrimination court says that it was decided earlier. It has never been considered. My lords will have the earlier orders. My lords, the issue of discrimination is not gone into by any of the courts. My lords will see only 2 pages, my lords, with respectful submission, my lords. Page 67, my lords, which is a chart of, my lords, how the land has been released by the state government, my lords.
You are not challenging those released before us.
My lords, I am seeking parity, my lord. Discrimination.
Where is the question of parity?
My lord, this honorable court has time and again held, my lords, in 2010 also, my lord, Jagdish and all those judgment, my lords, Sports City, my lords, they have said, my lords, that in discrimination has to be seen from that angle, my lords. If similarly situated landowners' land has been released, my lords, here, my lord, may see, my lords, may kindly have page 57, how they have gone about the acquisition. In village Islampur, section 4, 113 acres, section 6, 98 acres, area released before about 19 acres. Thereafter, my lords, it only comes down to 51 acres has been released, my lords. In totality, only 60 acres has been acquired. In total, the acquisition, 491 acres acquisition, my lords, only 160 acres is acquired. Well, this issue has to be gone into by someone, my lords, whether I was similarly placed with them or not, my lords. From the photographs, I can show, my lords, that the land which has been released is abutting those lands which have been released by the honorable, by the government, my lords, under section 5A. My lords will see the site plan also. My lords, I am surrounded on 3 sides by released lands. My lord, it is not that these people, my lord, these people.
Consent for the petitions, we do not find any ground to interfere with the informed judgment of the High Court. Respectfully, accordingly dismissed. However, keeping in the particular factual circumstances of the case, there are 10 of the impugned judgment to the extent of imposing post of rupees 25,000.
My lord, these people will be left without house, my lord, because of inaction of the state government and, my lord, the complete discriminative practice being adopted by them, my lord.
Very good, very good. You also ask someone to challenge it.
Please, my lord.
Please, my lord.
Highly obliged.
Because I'm praying for a time-bound disposal, my lords, because the tenure, my lords, of the house that terminates in early 2020.
Was the Chief Justice of the High Court.
My lords, the problem is, my lord.
Did the Supreme Court start?
My lords, I could draw a little bit of sustenance from your lordship's order, my lords, of 2020, my lords.
That's right. So that means, despite our orders, we are not hearing it. Then do you think what should we do?
Well, the similarity went to such an extent that the Honorable High Court was also the same, my lords.
Go and apply the.
My lords, if I may, my lords. Otherwise, my lords, what is happening is, my lords, what is happening is, my lords, that they are taking dates. It is being listed every day, my lords, with great respect.
Honorable Chief Justice of the High Court of Manipur, with liberty of ordinance and disposal.
Grateful.
I beg to appear, my lord, on behalf of the petitioner, my lord, is a tender taken out by Central Coalfields, my lord. Now, my lord, the clause in the tender in relation to additional performance security was in question in the first round of litigation because there was some lack of clarity. The High Court said, my lord, you have to do it. My lord, Caliber, who was the successful tenderer, came before this court, my lord. This court said, no, there is some
matter is pending before the High Court.
I know.
Whatever contention you have, you go and try there.
Let me explain, my lord.
So this was a petition which should have been dismissed by the High Court on the very first date. Unfortunately, notice has been issued, therefore go and argue.
No, my lord, let me explain, my lord.
You are blackmailing the system. You don't want to pay anything because you are successful bidder.
It's like this, my lord. Let me explain for a minute, my lord. If your lordship.
No, why should we entertain, Mr.
My
Lord?
lord, may I just explain, my lord? Serious prejudice is caused to me. I'll tell your lordships why, my lord. The debarment, my lord. Just give me a minute, my lord.
No, then we will impose cost on him. Then we will impose equivalent cost of the.
It's a
man is
blacklisting, my lord. It's
enjoy.
blacklisting. My lord, I have not been able to participate in other tenders. My lord, I can understand, my lord, CCL tenders, my lord.
Mr. Banerjee,
CCL tenders, I can understand.
how can you dispute the logic given by the High Court? That if we injunct the blacklisting order, we are putting the final relief at this stage.
My lord, I will just answer
And
that
this
question.
court order was very clear.
Can I just answer your lordship's question?
Why should we go and answer to the?
I'm not saying, my lord, that the blacklisting,
Only
my lord,
these
was
people can
CCL.
afford litigation because at sometime unfortunately they get bumper dry litigation. This is how people are encouraged to file frivolous and most dishonest litigation.
My lord, can I just answer your lordship's question, my lord? My lord, the CCL debarment order is limited to CCL. But the problem is I'm not able to participate in other tenders of the PSUs, my lord, because, my lord, each one of them has this clause.
They have an interrelated clause.
Correct.
That
Every
if
other
any
PSU
blacklist, you are out.
Not from every tender. That's the predicament I'm facing and the prejudice I'm facing, my lord. So it's
Just see the principles of injunction. Let us say in such a situation, it is found that the blacklisting was illegal, egregious, the compensation by way of money is available, even as a constitutional bond.
Today, my lord, I'm not able to participate, my lord. I have 26.
That is what we say, that if the
Compensation
CCL
may not-
will be subjected to a cost.
Compensation may not be an adequate remedy, my lord.
No case to entertain.
Can I just, my lord, request your lordship, my lord, the matter is posted, my lord. Would your lordship, my lord, request the High Court to take it up and, my lord, dispose it of?
We will not say anything.
I'm sorry, my lord.
No, we can't say, Mr. You go and tell the High Court.
Just the point that has no bearing.
Not that 11th August Supreme Court order has no bearing on the present matter. That was a different issue altogether. At least to that extent, lordships can clarify, my lord. At least to that extent, my lord, some clarification.